Good afternoon. My name is Renee Townsend, and I'm a partner at the Michigan-based law firm of Secrest, Wardle. Today's presentation is on the premises liability topic, Special Considerations for Landlords. This presentation is part of Secrest Wardle's 2018 Premises Liability webinar series. I want to thank you for joining me today. This topic, Special Considerations for Landlords, will include a review of the common law and statutory duties imposed on landlords, the various claims that can be made against landlords, and the defenses available to those claims. Without further ado, let's get started and talk about special considerations for landlords. And I want to start by just giving a quick refresher on some general premises liability principles before we get into the details of what would be specific to a landlord. The most basic place to start in any premises liability claim is to determine the status of the person on the land. That status determines what level of duty is owed by the landowner to the person on his land. And these are common law duties. They're not based on statutes. The duty a landowner or possessor of land owes to a person, again, depends on that person's status on the land. And there are three legal statuses, and we'll begin with the simplest one, trespassers. There is generally no duty owed by a landowner to trespassers except to refrain from engaging in willful and wanton misconduct. Willful and wanton misconduct is defined as conduct that shows such indifference to whether harm will result as to be equal to a willingness that harm will result. In other words, conduct that was intended to harm the trespasser being another way to get to that level of liability. We'll discuss the very limited duties owed to a trespasser later in this webinar, but I would also direct you to another webinar I presented, which you can find on our website, www.secrestwardle.com, which delves deep into the details of the Trespass Liability Act. The next level of legal statuses for a person on someone else's land is licensees. A landowner owes a licensee a duty to use ordinary care to prevent injury arising from the landowner's active negligence, and we'll discuss what that means shortly as well. Finally, the highest level of duty owed to an individual on a landowner's property is to invitees. A landowner owes an invitee a duty to use ordinary care to keep the premises in a reasonably safe condition. Now you can see the difference here between a licensee and an invitee. For an invitee, you only have a duty to avoid active negligence, while with an invitee, you have a duty to keep your premises safe for that person. Let's examine what those duties mean a little bit more closely. What is a trespasser? A trespasser is a person who goes onto the premises of another without their express or implied permission, for his own purposes, and not in the performance of any duty. Under most circumstances, landowners have no duty to keep their premises safe for trespassers. That means there's no duty to warn of any dangers or do anything to ensure that your premises are safe for people who are trespassing, even if those dangers are known to the landowner and could not be known to the trespasser. The only real duty owed is that you cannot actively harm the trespasser, so you can't set traps, and you've got to refrain from willful and wanton misconduct. Even so, that duty to refrain from active negligence toward a trespasser only arises after the premises owner becomes aware or should be aware of a trespasser's presence. Therefore, that duty does not encompass conduct that occurred before the trespasser arrived. However, a defendant may be liable to a trespasser when the defendant should have known that that trespassers constantly intrude on a limited area on the premises, and the plaintiff was harmed because the defendant carried on an activity in that limited area that involved a risk of death or serious harm and failed to use reasonable care for the trespasser's safety. So basically all that means is if you know that trespassers are regularly coming onto a certain area of your land and a portion of that area that is regularly being trespassed upon is used for something that has a serious risk of harm or death, you've got to do something in that instance to make the area reasonably safe. What is a licensee? A licensee is a person who is privileged to enter the land of another by virtue of the possessor's consent. So a landowner's duty here is to use ordinary care to prevent injury arising from the landlord's active negligence. A landowner is liable to a licensee for a condition on the land only if the landowner knew or should have known of the condition, should have realized that it involved an unreasonable risk of harm to a licensee, and should have expected that the licensee would not discover or realize the danger. The possessor failed to exercise reasonable care to make the condition safe or to warn the licensee of the condition and the risk, and the licensee did not know or have reason to know of the condition and the risk involved. However, there is no duty to inspect or warn except for concealed or hidden dangers of which the possessor actually knows. You should also note that when children are involved, a special rule imposing a higher degree of care may apply. Now, I call this the dumb kids rule, though that's not the official name. And what the dumb kids rule basically says is that a landowner is required to take into consideration that a child's ability to appreciate the full extent of the risk is different from that of an adult. So a higher degree of care is applied. The highest level of care is owed to an invitee. A person is determined to be an invitee when his visit can reasonably be said to confer a business, commercial, monetary, or other tangible benefit to the entity or the person possessing the land. Landlords, again, have the highest duty to invitees. They're required to maintain the premises, inspect the premises for any hazards, and warn an invitee of any hazards. And generally, a landlord is required to exercise ordinary care and prudence to keep the premises in a reasonably safe condition. So those are the basics of what you need to know about the duties owed by a landowner to a person who comes onto their land. But the term landowner is kind of misleading because a landowner is not the only person who may be liable in a premises liability case. The real issue is possession and control of the subject property. Normally, the proper defendant in a premises liability case is the entity that had possession and control over the property. So ownership is not dispositive, legal title is not dispositive. Liability depends on actual possession and exercise of control over the property. For a landlord, however, ownership of the land does keep you liable, even if you have relinquished possession and control to another party, like a management company, for example. Now, the entity currently in possession of control on the property also has duties to the plaintiff. So the management company can be sued right along with the landlord. They can both have legal duties owed and possession and control deriving those legal duties at the same time. But what about areas where possession and control is more questionable, like for berms and driveway approaches? Berms being the grassy area between the sidewalk and the street, and driveway approaches being the part of the driveway that is between the street and the sidewalk, or even including the sidewalk up to the actual driveway on a home or a building. Now, a homeowner or landlord does not possess or control the grassy area between the sidewalk and street adjacent to the homeowner's land when the city has an easement over that portion of the land. This is true even when there is a local ordinance that requires the homeowner to maintain and clear the easement of overgrowth. So even if you've got to mow that area and keep it maintained, there's no liability there for that portion of the land. This is also true where a city has an easement over a driveway approach and the homeowner has a duty to clear snow and ice on that approach, pursuant to the local ordinance. Now that we've addressed the common law duties for property owners in general and landlords specifically, we can discuss the specific statutory duties imposed on landlords in Michigan. The Landlord-Tenant Act can be found at MCL 554.139 and the subsequent statutes. That's what ETSEC means, the subsequent statutes. Now, the plain language of MCL 554.139 states that a landlord has a duty to keep the premises and all common areas fit for the intended use by the parties, and to keep the premises in reasonable repair during the term of the lease or license, and to comply with applicable health and safety laws of the state and the local unit of government where the premises are located. Common areas are defined as areas located within the parameters of an apartment complex, accessible to all tenants and maintained by the landlord or his employees, like the sidewalks and the grassy areas. So it's different from the areas inside of an apartment, for example, versus the areas that would be outside and accessible to all tenants. It should be noted that the parties to the lease or license may modify the obligations imposed by this section where the lease or license has a current term of at least 1 year. The statute also specifically states that it should be liberally construed and that giving the tenant or lessee an opportunity to inspect the premises before entering into an agreement does not free the landlord from these statutory duties. Most of you are probably aware of a doctrine called the open and obvious defense, but I'm going to go over it a little bit just to give you a refresher. The open and obvious defense essentially states that a landowner is not liable to an invitee for a condition on the land that is open and obvious. However, the open and obvious defense cannot be used to avoid a specific statutory duty. So in the case of a landlord, the open and obvious defense does not apply to cases where plaintiffs are claiming breach of a statutory duty, such as those imposed in the Landlord-Tenant Act. So for instance, the open and obvious defense does not apply to a landlord's duty to keep the premises in reasonable repair, keep the premises fit for its intended use and purpose, or follow local ordinances. However, if the plaintiff fails to prove a breach of a statutory duty, the open and obvious defense does apply. I want to make a quick couple of specific points relative to the statutory duties of landlords and the open and obvious doctrine. The first being the social guest exception. The Michigan Supreme Court has held that the duties imposed by the Landlord-Tenant Act exist only between the contracting parties, being the landlord and the tenant. Therefore, the statutory duties do not apply to social guests of the lessee. What this means is that a social guest cannot claim, for instance, that the landlord failed to keep the subject premises in reasonable repair to avoid the open and obvious defense. The open and obvious defense will apply to that social guest. The next thing is a question may arise as to whether a landlord owes those statutory duties that we discussed above as related to a fixture on the property. And to understand that, we first need to understand what is a fixture. The term fixtures generally means any personal property that is affixed to the real property. This is hard to define, but perhaps the clearest answer was offered by Professor Steve Nippenberg of the University of Oklahoma College of Law. He said, "You take the world, you shake it, and everything that doesn't fall off is a fixture." My personal favorite answer is to paraphrase U.S. Supreme Court Justice Potter Stewart in the old case of Jacobus versus Ohio. A fixture is like pornography. It's hard to define, but you know it when you see it. Some samples of possible fixtures include anything from furnaces, sinks, countertops, solar panels, and wind turbines. A landlord generally does not owe those statutory duties in the Landlord-Tenant Act relative to claims involving fixtures. For example, one case where there was a pilot light that went out on a furnace, and the landlord instructed the tenant to relight it himself, leading to an explosion and fire. The landlord was not liable for statutory claims made under the Landlord-Tenant Act because that case involved a fixture. Finally, I want to discuss the issue of notice. Where a landlord does not have notice of an allegedly defective condition, Michigan courts have held that the Landlord-Tenant Act does not apply. And again, by way of example, in one case, a plaintiff attempted to close a sliding glass door, but it would not close properly. The plaintiff pushed on the door with both hands in an attempt to close it completely. In doing so, the plaintiff's hand slipped and went through the glass pane in the door, and she sustained serious injuries. The plaintiff asserted a breach of the statutory duties under the Landlord-Tenant Act, but the court held that because the landlord was not on notice of any allegedly defective condition, being the defective door, neither statute applied, or neither portion of the statute applied. This same principle applies most frequently in Michigan in snow and ice cases. In case you're unaware, Michigan winters sometimes produce snow and ice. And sometimes Michigan winters dump ungodly amounts of snow and ice on Michigan residents who question why they have chosen to live their one life on this earth in a state that's a frozen tundra for 5 months out of the year. But that aside, the Michigan Court of Appeals has repeatedly held that a landlord must have had actual or constructive notice of the existence of the alleged icy or snowy condition to trigger a duty to diminish the hazard. Absent some evidence that the icy condition had existed for any length of time sufficient that the landlord should have known about it, or that the landlord actually knew about it, there is no basis for liability against the landlord. However, notice is not the only hurdle that plaintiffs must overcome in a snow and ice case. Michigan courts have held that a landowner can still be liable for an open and obvious condition on the land where that condition has some special aspect. A special aspect can be a condition which created an unreasonable risk of harm to the plaintiff, or a condition that was effectively unavoidable by the plaintiff. The touchstone of the special aspects analysis is that the condition must be characterized by its unreasonable risk of harm. Thus, an unreasonably dangerous hazard must be just that, not just a dangerous hazard, but one that is unreasonably dangerous. And it must be more than theoretically or retrospectively dangerous. Similarly, an effectively unavoidable condition must be an inherently dangerous hazard that a person is inescapably required to confront under the circumstances. However, it is not a landlord's duty to guarantee that ice never forms anywhere on its property. As long as you provide a reasonable means of ingress and egress, meaning to clear your walkways and sidewalks, you have met your duty under the common law. So if Grandma Josephine wants to walk on unsalted and unplowed snowbanks, she does so at her own risk. All premises owners in Michigan have these same duties and protections with regard to snow and ice. However, landlords have additional statutory duties under the Landlord-Tenant Act. The Michigan Supreme Court has held that parking lots and sidewalks in leased residential areas are common areas under MCL 554.139, subsection 1A. As we discussed earlier, a landlord has a duty to keep the premises in reasonable repair and fit for its intended use and purpose. It follows then that to determine whether a premises is fit for its intended use and purpose, you would first have to determine what the intended use and purpose of a certain area is. For this analysis, sidewalks are not equal to driveways, are not equal to parking lots. Sidewalks are intended for pedestrian use. Driveways are intended for pedestrian use and parking vehicles. And parking lots are intended for parking vehicles and pedestrian access to parked vehicles. I want to focus on driveways and parking lots for a second. While at first glance it may seem that the intended use and purpose of a driveway and a parking lot would be the same, i.e. parking vehicles and allowing people access to those vehicles, they may not necessarily be treated equally. Driveways that grant access to garages and residential units may be deemed more akin to sidewalks than parking lots. However, just because someone uses a driveway to access a certain area on foot does not make that area akin to a sidewalk without some evidence to support the claim that the intended use of the driveway was for pedestrian traffic. This becomes evident when you compare two recent decisions from the Court of Appeals, one in 2016, one in 2017, Hendricks v. Lautrec and Duff v. J. Wellington Enterprises. In Hendricks, plaintiff alleged that an icy patch on the driveway caused from the path of runoff from a downspout was a dangerous condition that rendered the driveway unfit for pedestrian use. The court took note of the Michigan Supreme Court's landmark and hallmark decision in Allison v. AEW Capital Management, LLP, which held that the primary use of a parking lot is to park cars, and the statute does not require a lessor to maintain a lot in an ideal condition or in the most accessible condition possible, but merely requires the lessor to maintain it in a condition that renders it fit for use as a parking lot. However, the Hendricks majority ultimately concluded that a driveway is not a parking lot, noting that the driveways on the premises in question were used for pedestrian access to garages and residential units. In this sense, the majority held, the driveways were more akin to sidewalks. Sidewalks, the court then noted, are intended for the use of pedestrians. The court concluded that where a substantial portion of the driveway abutting the plaintiff's driveway was covered in ice, the majority held that this ice created a dangerous condition, making the driveway unfit for pedestrian use. The appellate panel then reversed the dismissal of plaintiff's statutory claim and remanded for continued proceedings. However, 1 year later, the Court of Appeals issued another decision, Duff v. J. Wellington Enterprises, which appears to be at odds with the decision set forth in Hendricks. These conflicting decisions indicate that the determination of whether a driveway is fit for its intended use and purpose may be fact-specific. In Duff, the plaintiff was injured when he slipped and fell on black ice while walking on an asphalt driveway at a campground where he lived and worked. The plaintiff sued his landlord and argued that the area of asphalt that he slipped on, which was part of a driveway, but also ran adjacent to a convenience store and may be used for foot travel into the store, was unfit for its intended use of pedestrian travel given the slippery conditions. This dispute concerned the actual intended use of the area. Plaintiff claimed that it was for walking, while with the only evidence being that the plaintiff himself was walking in the area when the slip and fall occurred. The court found that the primary intended use of the driveway was in fact to accommodate vehicular traffic, and further that there was no evidence that the roadway was unfit for vehicular use or accessing vehicles. The court noted the plaintiff's unsupported assertion that the subject area was intended primarily for walking did not create a question of fact sufficient to survive summary disposition. The court cited Wilson v. Taylor, a 1998 Michigan Supreme Court case, when it stated that an appellant may not merely announce his position and leave it to this court to discover and rationalize the basis for his claims. Here, the plaintiff made claims that the area was intended for walking, yet when the court pressed him to support those assertions, he was unable to do so, and summary disposition was upheld. So the long and short of it is that this question that will likely have an answer that continues to evolve. Though it will be very fact-specific to your premises case, you and your counsel will have to determine whether the facts in your case involving a driveway lean more favorably to comparisons with a sidewalk or a parking lot. Let's move on and talk about the big issue in Michigan, or continue to talk about the big issue in Michigan premises cases, snow and ice. There are certain rules to keep in mind when it comes to snow and ice. These stem from both statutory duties and the application of those statutory duties to the common law. As I said before, parking lots and sidewalks in leased residential areas are considered common areas. The natural accumulation of snow and ice is subject to the lessor's duty, but a plaintiff must show that the area was not fit for its intended use under MCL 554139, Section 1A, which provides that the lessor has a duty to keep the common areas fit for its intended use. The landlord's duty in this regard concerning the accumulation of snow and ice is to keep the entrance to and the exit from the lot clear, to make sure that the vehicles can access parking spaces, and that tenants have reasonable access to their parked vehicles. There have been cases in which a tenant has alleged that to have slipped and fall on ice in a parking lot, only to have that case dismissed because evidence was presented that other people were able to walk through the parking lot without falling. The courts have held that to be evidence that the parking lot was fit for its intended use. But the natural accumulation of snow and ice is not subject to the lessor's duty established in MCL 554.139, Section 1B, which concerns damage to the property and the landlord's requirement to repair the damage. The courts have held that the accumulation of snow and ice does not constitute a defect in the property, and therefore the lessor would have no duty under MCL 554-139 subsection 1B with regard to snow and ice, except to the extent that such snow and ice cause damage to the property. A final note on snow and ice: if you are a landlord who is renting out a standalone house, you can draft a lease that puts the responsibility for snow and ice and other maintenance onto the renter. This eliminates the statutory and common law duties of snow and ice maintenance that would normally be imposed on the landlord. It becomes the tenant's problem. Well, it's finally beautiful in Michigan, so I don't want to talk about snow anymore. I'm sick of it. It lasted too long. Let's move on to things that come out when the weather gets warm. Michigan summers, the snow goes away, maple trees come alive, lakes warm up, and the spiders come out. So the question becomes, what duty does a landlord have with regard to bug infestations? The answer is none, really. Unless the plaintiff can prove that there was damage to the premises that was caused by the spiders or contributing to the presence of spiders, it cannot be established that the landlord failed to keep the premises reasonably repaired as required by MCL 554.169 subsection 1B. A big issue that recently has come up has been bed bugs, and it follows that same line of reason. Unless the plaintiff can prove that the landlord did anything that would have contributed to the bedbug presence, liability cannot be established. Another issue that comes up a lot is dogs, and pit bulls in particular. Michigan courts have rejected the argument that property owners should be strictly liable for attacks by their tenants' dogs. Unlike dog owners, who are strictly liable for injuries inflicted by their dogs under the dog bite statute, more is required to impose liability on a landlord. A landlord is liable for injuries caused by the attack of a tenant's dog only where the landlord had actual knowledge of the dangerous propensities of the dog and where the landlord, having that knowledge, nevertheless leased the premises to the dog's owner or by the terms of the lease had the power to control the harboring of a dog by the tenant and neglected to exercise that power. That language comes from Braun versus York Properties, a Michigan appellate court case from 1998. So in short, such cases often turn on whether the landlord knew that the dog had exhibited dangerous propensities before the incident. With pit bulls in particular, it has been argued that a landlord should be held to have known about a pit bull's dangerous propensities just by the supposed violent nature of the dog breed. However you feel about pit bulls, the point remains the same. The landlord must have known about that particular dog's dangerous propensities and not just about the danger of a breed in general. Even where a lease sets forth rules and regulations about keeping pets in a rented property, the landowner or landlord has no duty unless he knows about the dangerous propensities of the dog. Some plaintiffs have also attempted to bring nuisance claims against landlords for their tenants' ownership of a pit bull, but those claims are typically easily defeated because a defendant cannot be held liable for nuisance unless he had possession or control of the land. Ownership of the land does not create liability in nuisance, and generally a landlord is not liable for a nuisance created by the tenant. Though spiders and pit bulls may be scary to some, the issue of criminal activity is another concern for landlords. Michigan courts have held that a landlord owes a duty both to tenants and their guests to take reasonable measures in response to an ongoing crime that takes place on the premises. This generally means calling the police. Landlords are not expected to fight crime themselves. The Supreme Court has also held that landlords have no duty to respond to criminal activity within rental units. A landlord's duty arises only when the triggering conduct occurs in those areas under the landlord's control. A final couple quick notes before we wrap up. What about condos? Condominiums, condominium owners, and condominium associations are not covered by the Landlord-Tenant Act because there is no landlord-tenant relationship and no lease involved. For example, a recent Michigan Court of Appeals case, Francis Cutie versus Fox Chase Condo Association, involved a claim by a condo owner against a condo association for an alleged defect in the common area on the property. The Michigan Court of Appeals held that even the common areas are not subject to any duty under the Landlord-Tenant Act because they are not covered by a lease. Instead, premises liability cases involving condos are governed by the Condominium Act and the duties and obligations set forth therein. MCL 554.633, commonly known as the Truth in Renting Act, states that a rental agreement shall not include provisions that does one or more of the following: waives or alters a remedy available to the parties when the premises are in a condition that violates the covenants of fitness and habitability required pursuant to MCL 554.139, and exculpates the lessor from liability for the lessor's failure to perform or negligent performance of a duty imposed by law. So exculpatory clauses in residential leases have been held to be void as against public policy. Finally, all of the things we've discussed today deal with residential leases. A quick note on commercial leases. A commercial lease is treated as any other contract, so unlike residential leases, you can have all of the good stuff. Commercial leases may include provisions for releases, indemnity, exculpatory clauses, switching responsibility to tenants, switching possession and control to tenants, making tenants identify you as an additional insured, shortening statutes of limitations, and other provisions which may be particular to your property. You can have all that stuff in a commercial lease when you couldn't have it in a residential lease. So we've reached the end of the presentation. I hope the information has been helpful to you and gives you a better understanding of the duties, obligations, and protections specifically afforded to landlords under the Landlord-Tenant Act and the common law in Michigan. My contact information is now on the screen. You can look me up on our website, again, www.secrestwardle.com, or on LinkedIn by my name. I look forward to hearing from you with any feedback, questions, or my strong preference, compliments, and accolades. So if you do want to discuss this matter further, or if you want the slides or anything like that, just shoot me an email or give me a call. I hope you all enjoy the rest of your day, and I thank you again for taking the time to attend the presentation.